the relevant pieces of legislation governing the composition and jurisdiction of the High Court are the Constitution of Zimbabwe and the High Court Act. In terms of Section 170 of the Constitution, the High Court is a superior court of record and consists of the Chief Justice, the Deputy Chief Justice, the Judge President of the High Court, and such other judges of the High Court as may be appointed from time to time. The qualifications for appointment as a judge of the High Court are set out in Section 179 of the Constitution. In terms of Section 3 of the High Court Act, in a criminal trial, the High Court is considered duly constituted if it consists of one judge of the High Court and two assessors. When reviewing any criminal proceedings of an inferior court, one or more judges are required, while in an appeal, it should consist of at least two judges of the High Court. Assessors are not required in reviews or appeals. Section 6, subsection 1 of the High Court Act sets out the qualifications for assessors as follows. A person shall be qualified to act as an assessor in a criminal trial in the High Court if he has experience in the administration of justice, or he has experience or skill in any matter which may have to be considered at the trial, or in the case of a trial involving a juvenile, he has experience or skill in dealing with juveniles, or he has any other experience or qualification which, in the opinion of the Chief Justice and the Judge President, renders him suitable to act as an assessor in a criminal trial. In terms of Section 6, subsection 2 of the High Court Act, the Minister of Justice prepares the list of assessors, and the list must be approved by the Chief Justice and the Judge President. The choice of the two assessors is made from the list by the Registrar of the High Court. However, the Chief Justice or the Judge President may direct the Registrar of the High Court as to the manner of choosing the assessors from the list. The function of assessors is to decide questions of fact. They do this together with the judge. The decision of the court on matters of fact is reached by a majority. Therefore, if the two assessors reach a conclusion different from that of a judge, their view prevails. The judge alone decides on matters of law, including deciding on whether a question is that of law or of fact. Where there is a difference of opinion on a matter of fact, the judge must give reasons for the dissenting member, even if the dissenting member is an assessor. It is common for judges of the High Court to disagree. Section 4 of the High Court Act provides what should happen in the event of a difference of opinion. Section 4 of the High Court Act reads, when more than two judges of the High Court are sitting together, the decision of the majority shall be the decision of the High Court. Whenever there is a difference of opinion on an appeal or application or any other matter being heard by an even number of judges of the High Court sitting together and the opinions are equally divided, the decision of the High Court shall be suspended until the opinion of a further judge of the High Court has been obtained. Thereupon, the decision of the majority of such judges shall be the decision of the High Court. If at any stage during the hearing of an appeal or application or any other matter by three or more judges of the High Court, any such judge dies or retires or is otherwise unable to sit as a member of the High Court or absent, the presiding judge may in his discretion direct that the appeal or application shall proceed before the remaining judges or that a further judge of the High Court be obtained to sit. In any case in which a decision has been suspended in terms of subsection 2, in order to obtain the opinion of a further judge of the High Court, or a further judge of the High Court has been obtained to sit in terms of subsection 3, the presiding judge may direct the recalling of any witness or order further argument before the judges who originally constituted the court and the further judge. If a matter being heard by the High Court involves a difficult question of law, or if at any stage during the hearing of a matter by one or more judges, such a question arises, the presiding judge may direct that the hearing of that matter or the hearing in respect of that question shall proceed before such greater number of judges than 2 as may be determined by the Chief Justice or the Judge President, and thereupon the decision of the majority of such judges shall be the decision of the High Court. Section 171 of the Constitution provides for the jurisdiction of the High Court. Section 171 of the Constitution reads, "The High Court has original jurisdiction over all civil and criminal matters throughout Zimbabwe. He has jurisdiction to supervise magistrates' courts and other subordinate courts and to review their decisions. May decide constitutional matters except those that only the Constitutional Court may decide, and he has such appellate jurisdiction as may be conferred on it by an Act of Parliament." Section 23 of the High Court Act also makes it clear that the High Court has full original criminal jurisdiction over all matters throughout Zimbabwe. This means that there is no limit to its jurisdiction regarding the nature of the crime, the possible punishment, and the location in Zimbabwe where the crime is committed. As of 2025, the High Court sits permanently in Harare, Bulawayo, Mutare, and Chinhoyi. This is the High Court of Zimbabwe located in Harare. Look out for the common landmark, the Reserve Bank of Zimbabwe, which is just adjacent to the court. It's a superior court of record, and we have many other in other places, as I have mentioned. The jurisdiction of the High Court over persons is limited by Section 98 of the Constitution, which gives the President immunity from any court proceedings in any court whilst in office. The High Court also has extraterritorial jurisdiction over statutory crimes where the statute in question has extraterritorial effect. The High Court can also exercise jurisdiction over crimes committed wholly or partly outside Zimbabwe in terms of Section 5 of the Criminal Law Codification as follows. If the conduct which completed the crime took place in Zimbabwe, if the crime is against public security in Zimbabwe, if the crime has produced or was intended to produce a harmful effect in Zimbabwe, or was committed with the realization that there was a real risk or possibility that it might produce such an effect. The leading case in point is the case of State v. Marapara, where it was held that the High Court had jurisdiction to try a Zimbabwean diplomat who, whilst in a foreign country, stole money belonging to the Zimbabwean government. The High Court has power to review all proceedings and decisions of inferior courts in Zimbabwe. However, it is important to note that the High Court cannot review sentences imposed by Parliament on its members for contempt, even though Parliament is sitting as a court. Parliament can now impose only a sentence for contempt in terms of Section 148, subsection 2 of the Constitution. The High Court has the power to hear appeals from the decisions of the magistrates in criminal cases, both in regard to conviction and sentence in terms of the Magistrates Court Act. The relevant pieces of legislation governing the operations of the Supreme Court are the Constitution of Zimbabwe and the Supreme Court Act. In terms of Section 168 of the Constitution, the Supreme Court is a superior court of record and consists of the Chief Justice and the Deputy Chief Justice, no fewer than 2 other judges of the Supreme Court, and any additional judges appointed under subsection 2. The qualifications for appointment as judges of the Supreme Court are set out in Section 178 of the Constitution. In terms of Section 3 of the Supreme Court Act, for exercising its jurisdiction in any matter, the Supreme Court is duly constituted if it consists of not less than 3 judges, of whom one must either be the Chief Justice or a permanent judge of the court. In matters involving the application, interpretation, and enforcement of an infringement of the Constitution, the Chief Justice or the Judge President may direct that the court be duly constituted by at least 5 judges of the Supreme Court. In the event of such a directive, even the matter involving the interpretation of the Constitution may also be heard by 3 judges. This is also in terms of Section 3 of the High Court Act. This is the Supreme Court of Zimbabwe, a superior court of record, and it is located in Harare. We have only one Supreme Court in Zimbabwe, which is located in Harare. Section 169 of the Constitution provides for the jurisdiction of the Supreme Court. Section 169 of the Constitution reads, "The Supreme Court is the final court of appeal for Zimbabwe, except in matters over which the Constitutional Court has jurisdiction. Subject to subsection 1, an Act of Parliament may confer additional jurisdiction and powers on the Supreme Court. An Act of Parliament may provide for the exercise of jurisdiction by the Supreme Court and for that purpose may confer the power to make rules of court. Therefore, the Supreme Court is the final court of appeal in Zimbabwe. It has jurisdiction to hear appeals in criminal matters from any court or tribunal in which, in terms of any Act of Parliament, an appeal lies to it. This is in terms of Section 9 of the Supreme Court Act. Under our current law, the Supreme Court hears appeals from the High Court, and it is no longer permissible to make appeals directly from the Magistrate Court to the Supreme Court. The Supreme Court sits only as an appellate court and does not have original jurisdiction. The relevant pieces of legislation governing the operations of the Constitutional Court are the Constitution of Zimbabwe and the Constitutional Court Act. This is the Constitutional Court of Zimbabwe, a superior court of record. It is located very close to the High Court of Zimbabwe and it is only located in Harare. In terms of Section 166 of the Constitution, the Constitutional Court is a superior court of record and consists of the Chief Justice and the Deputy Chief Justice and 5 other judges of the Constitutional Court. The qualifications for appointment as judges of the Constitutional Court are in terms of Section 177 of the Constitution. In terms of Section 4, subsection 2 of the Constitutional Court Act, for the purpose of exercising its jurisdiction in a case concerning alleged infringements of a fundamental right enshrined in Chapter 4 of the Constitution, the court shall be constituted by all the judges in accordance with the provisions of Section 166, subsection 2 of the Constitution. Section 167 of the Constitution provides for the jurisdiction of the Constitutional Court. Section 167 of the Constitution reads, "The Constitutional Court is the highest court in all constitutional matters, and its decisions on those matters bind all other courts. Decides only constitutional matters and issues connected with decisions on constitutional matters, in particular references and applications under Section 131, subsection 8b and paragraph 9, subsection 2 of the 5th Schedule, and makes the final decision whether a matter is a constitutional matter or whether an issue is connected with a decision on a constitutional matter. Subject to this Constitution, only the Constitutional Court may advise on the constitutionality of any proposed legislation, but may do so only where the legislation concerned has been referred to in terms of this Constitution. Hear and determine disputes relating to election to the office of President. Hear and determine disputes relating to whether or not a person is qualified to hold the office of Vice President, or determine whether Parliament or the President has failed to fulfill a constitutional obligation. The Constitutional Court makes the final decision whether an act of parliament or conduct of the president or parliament is constitutional and must confirm any order of constitutional invalidity made by another court before that order has any force. Therefore, the Constitutional Court is the highest court in all constitutional matters and decides only constitutional matters and decisions connected to constitutional matters. The Constitutional Court only deals with criminal cases to the extent that they involve constitutional issues. In conclusion, our main criminal courts in terms of Section 193 subsection A of the Constitution are as follows: the Magistrate Court, the High Court, the Supreme Court, and the Constitutional Court being the highest court in constitutional matters, and it only deals with criminal matters to the extent that they involve constitutional issues. Also take note that we have so many magistrate courts in all the 10 provinces of Zimbabwe, and as of 2025 we have the High Court sitting in Harare, Bulawayo, Mutare and Chinhoyi, and we have only one Supreme Court and one Constitutional Court located in Harare, Zimbabwe. This marks the end of our discussion on the main criminal courts in Zimbabwe. We shall be covering other tribunals dealing with cases under disciplinary law in terms of Section 193B of the Constitution on our next video. They are also criminal courts. Thank you for joining us on Legally Dephine, and don't forget to like, share and subscribe. Also, share your comments and questions in the comment section.